So friends, Donald Trump's vindictive prosecution of former FBI Director James Comey is barely 1 week old. And Donald Trump's DOJ attorneys have already suffered their first defeat in the case. But it gets even worse for them, because what they just tried to do to James Comey before the judge shut them down, denying their motion, what they just tried to do may actually add fuel to James Comey's vindictive prosecution defense. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, Donald Trump's hapless DOJ attorneys just showcased their incompetence in an absurd motion they filed in the James Comey prosecution, the case that Donald Trump directed them to bring against his enemy, James Comey. Let's start with the new reporting, and then we're going to have a look at the judge's ruling. But first, this from MSNBC. Headline: Comey wins early discovery fight as judge finds Trump DOJ stance would cause needless delay. Accepting Lindsey Halligan's proposal, the judge wrote, quote, would unnecessarily hinder and delay defendants' ability to adequately prepare for trial. And that article begins, it's early yet in the James Comey case, but the former FBI director got a quick win on a procedural issue that reinforces the presiding judge's refusal to allow needless delay in the criminal case against the Donald Trump critic brought by a Trump-installed prosecutor. That reinforcement came from U.S. District Judge Michael Nachmanoff, who rejected the Justice Department's motion for a protective order that would have limited Comey's access to discovery. The judge wrote that the Trump DOJ's proposal, quote, would unnecessarily hinder and delay defendant Comey's ability to adequately prepare for trial. In a 2-page order explaining his decision Monday, Judge Nachmanoff, a Biden appointee sitting in the Eastern District of Virginia, noted that prior high-profile false statement cases didn't have the sort of limitations the government proposed here. The judge added that the DOJ proposal didn't sufficiently detail the information purportedly needing protection, thus making the request overbroad. Now, friends, before we turn to Judge Nachmanoff's very short order, it's about a page and a half long, ruling that Comey wins and DOJ loses, let me set it up. Let me talk a little bit about discovery and protective orders. When a crime is being investigated by any law enforcement agency, there is all kinds of paperwork generated by the police, by the FBI, right? There are police reports, there are evidence reports, there are maybe crime scene photos, there are audio recordings, there are forensic tests that are run on items of evidence, there are forensic searches of computers and phones, there are cell site records, and there's all sorts of stuff, evidence, information that is accumulated during the course of a police investigation. Much of that, once somebody has been indicted, has to be given to the defense in discovery. So when we talk about discovery, that's what we're talking about, all that stuff. Rule 16 controls what has to be given to the defense and the things that don't have to be given to the defense. But every defendant is entitled to discovery, all of the stuff that he or she needs to prepare for trial, because the defense attorneys have a right to investigate all of the allegations in the indictment, and they need all of the discovery, the information that was accumulated during the police investigation. They need it to conduct their investigation and to prepare for trial. That's discovery. A protective order is sometimes something that the prosecutors will ask for when they're giving discovery over. They will say, well, Your Honor, we don't want the defendant to just make copies of everything and put it out in the public square, make it available publicly. Or they might say, there are a couple of documents in here that are classified that have national security implications, so we don't want the defendant to necessarily have his own copy of that. He can look at it while he is with his lawyers preparing for trial. But so there are different kinds of protective orders. They limit, this is what the prosecutors ask for, they want the judge to issue a protective order limiting what can be done with maybe some discrete portion of the discovery. But here's the thing, friends. In every criminal case, the defendant is entitled to his or her discovery. I can tell you in my 30 years as a prosecutor, when there were pretrial detainees at the D.C. jail who were being held pending trial, their jail cells would be full of their own discovery. Why? Because they would spend time poring over it and reading it and preparing for the defense and meeting with their defense attorneys. And one of the things we had to guard against was somebody in maybe an adjacent cell getting a hold of somebody else's discovery and then coming to the prosecutor saying, oh, hey, I can be a snitch on that person because he confessed the crime to me. Yeah, that's right. And sometimes we would learn that that kind of a person had read the discovery of another inmate and was trying to sell to the prosecutors that the inmate confessed. I sniffed those people out every time. We would test the story, the information they were bringing to us to make sure, they didn't do something like that. That's a little bit of a detour I took there. But the point is, jail cells are filled with discovery. The defendants get their discovery. Now, friends, let's turn to what these Bush League prosecutors tried to do in the James Comey case. In essence, they tried to convince Judge Nachmanoff that James Comey shouldn't have his discovery. Now, he should only be able to look at it in the presence of his defense attorney, as if he has to be babysat because he can't be trusted with his own discovery. That is, in essence, what they were seeking, a protective order saying, no, maybe with a few discrete exceptions, the defendant, James Comey, can't have his discovery. He can't be trusted with it. Are you kidding me? Here is how Judge Nachmanoff handled that request from the prosecutors. In the case of United States of America versus James B. Comey Jr. defendant order. This matter comes before the court on the government's, the prosecutors, DOJ's, first motion for protective order and defendant James Comey's response thereto. The parties have submitted competing protective orders to govern discovery in this matter. The government, the prosecutors, DOJ, propose prohibiting defense counsel from leaving discovery with defendant James Comey and urges that all discovery should qualify as, quote, protective material, close quote. And friends, can I point out there that the judge was obviously highlighting a mistake, a typo in the prosecutor's submission, because this is not protective material, it is protected material. My editorial addition. For his part, defendant Comey provides further definition for what constitutes protected material. The judge is pointing out there that that would be the correct term, protected material. Defendant Comey provides further definition for what constitutes protected material and asks the court to not impose additional restrictions on the provision of protected material to defendant or defense counsel's ability to share protected material with prospective witnesses. The court shares the government's concern regarding the possibility of inappropriate dissemination of sensitive information, as well as the defendant's concern regarding his ability to defend himself, and both parties' interest in a fair trial. In balancing these considerations, the court finds that the circumstances of this case do not support the government's, DOJ's, the prosecutors' proposed limitations on the sharing of protected material with defendant Comey or with prospective defense witnesses, which would unnecessarily hinder and delay defendants' ability to adequately prepare for trial. And then there is a footnote that Judge Nachmanoff drops, and I'm going to circle back to that in a minute. The court further finds that the government's, the prosecutors, DOJ's proposal does not sufficiently define the information constituted protected material, thereby making it overbroad. Accordingly, it is hereby ordered that the government's, the prosecutors' first motion for protective order is denied. It is further ordered that defendant Comey's proposed protective order is adopted and will be separately entered in an order to follow. And now, friends, let's get to the money line, the footnote that Judge Nachmanoff drops in his order. And let me set it up. Recall how James Comey's lawyers, on the day he was arraigned 1 week ago, said that we will be filing a motion to dismiss based on vindictive prosecution and based on selective prosecution because my client, James Comey, is being prosecuted vindictively as evidenced by Donald Trump's endless statements and posts about him, and he's being prosecuted selectively for something nobody else in a comparable position or circumstance would be prosecuted for. Against that backdrop, here is what Judge Nachmanoff says in the footnote. The court observes that protective orders entered in numerous other high-profile false statements cases within and outside of this jurisdiction do not contain such limitations. And then he lists cases including United States versus McDonnell, former Virginia governor, United States versus Libby, that would be Scooter Libby, United States versus Blagojevich, that would be Rod Blagojevich, United States versus Manafort, that would be Paul Manafort. Friends, did you see what Judge Nachmanoff did there? He put information in that footnote in his order that tends to show that the prosecutors in James Comey's case are treating Comey selectively and more harshly, some might even say vindictively, than DOJ prosecutors treated other high-profile defendants in very similar cases, false statements cases. High-profile defendants like Governor McDonnell and Scooter Libby and Rod Blagojevich and Paul Manafort. DOJ prosecutors didn't ask for any of these harsh conditions, these limitations on discovery, these protective orders, the way they are doing to James Comey. Kind of feels a little selective, maybe even a little vindictive. And that footnote may give Comey's defense lawyers even more ammunition to argue that the case should be dismissed based on vindictive and selective prosecution. I mean, these prosecutors for the Department of Justice, Lindsey Halligan and these other two that she brought up from North Carolina, they are showcasing their incompetence. And if this continues, I strongly suspect there will be no trial. The judge may very well just dismiss the case outright on a motion to dismiss for vindictive and/or selective prosecution. That may be exactly the result we see in this case, because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.